So welcome everyone, good morning, good afternoon. I just want to introduce myself for those who don't know me yet. I am Fanny Dastugue, I am the Director General of CICA, which is the International Confederation of Contractors. We are very pleased to welcome you all for this webinar, which is the first of a series that we decided to launch together with Yasemin as part of a long-lasting collaboration between CICA and the DRBF. So the philosophy behind this initiative is really to encourage the parties to consider from the early procurement stage the use of dispute board as a contemporaneous dispute resolution mechanism and to share best practices for an efficient implementation. So really the main objective of this webinar series is to share the relevant information and experience among our contractors communities, to present the advantages of dispute boards, but also to address the challenges. So to that end, we will discuss with reputable guest speakers from the employers, engineers or project managers, and contractor sides to highlight the different perspectives. So today is an introduction to the concept of dispute boards, and we are very honored to have with us Suzanne, Paul, and Benoit. So we will make proper introductions of our speakers later on. I'd like to let you know the next steps for this webinar series. So we will organize the next webinar in mid-October, and we will deal with appointment issues, with a comparison between FIDIC 1999 and 2017 in order to understand what's expected to happen in the coming years. Then we will have an in-person conference in Paris on November 26th, hosted at our headquarters. And we will discuss the dispute boards from FIDIC and NEC perspectives. So as for these webinars online, we will circulate the invitations to you by email. Then, as you may know, CICA has a historic connection with the MDBs, multilateral development banks, and we are also promoting the concept of dispute boards at this level. We did jointly with DRBF in Washington at the World Bank and Inter-American Development Bank earlier this year, and we will do it again at the African Development Bank in Abidjan in September. So we will also organize a webinar on the efficient use of DBs and the bank's approach with potential contributions from development banks in early 2025. So now I will leave the mic to Yasemin Cetinel, board member and past president of DRBF Region 2.
Thank you very much, Fanny. I hope everyone can hear me. Welcome again. It's a real pleasure to see participation from all around the world. Indeed, we wanted to keep this webinar specifically at this hour in order to be able to embrace all the continents. So I thank Fanny for the very comprehensive introduction. We as the DRBF are trying our best to cooperate at an institutional level for the dispute board mechanisms promotion worldwide. And this webinar series is another initiative by this task group initiated between the two institutions. We really truly believe that the dispute board mechanism has many advantages, long-term contributions to the construction sector for all the stakeholders, not only one player or the other. And as Fanny mentioned, of course, this is an introductory level webinar because it's the start of the series. However, we have very distinguished speakers in our panel in order to put, even at an introduction level, the issue with a very wide industry practice of our panelists. So again, we are very pleased to have a substantial number of participation and registration, and it proves it is the right time for all the parties involved in this process to start getting more informed and stay active and more informed of the news and of the mechanism's efficiency. I will do my best to have a very brief introduction at a conceptual matter. We need that. Although I'm pretty sure the audience is very knowledgeable on the concept itself, let us have this introduction, and then I will leave the floor to our distinguished panelists accordingly. We will be moderating the panel with Fanny, of course, as a joint effort, and it is a pleasure as always. So, by way of introduction, the dispute board concept, we as DRBF always define it as what is a dispute board? The dispute board is a board of professionals, impartial and experienced in their fields, formed at the beginning of the project, of each construction project, to follow the progress of the construction, encourage parties to have a platform of open speech, dispute avoidance accordingly, and assist in case there are any disputes in the very quick and efficient resolution of such disputes. Now, because this board is formed at the beginning of the project, and because of the qualities of the board that the board should have, which is another topic that we will be elaborating in the next webinar in this series. As of the outset, this brings integrity and independence elements to the process. So the board keeps the equal distance between the parties, namely the employer and the contractor, and ensures that the disputes, if not avoided, are real-time resolved, because the board is visiting the site, getting familiar with the contracts and the projects and the project team. As opposed to dispute resolution types like arbitration, for example, the dispute could be avoided or could be resolved very efficiently, not, for example, like in arbitration, at a time that there are many disputes evolved and there is no relationship remained between the parties. So it is very difficult for the resolution to be as efficient. And accordingly, we always define the board members as part of the project team. So this is a project tool, in other words, that if executed properly, it serves to the successful completion of the project for everybody, not for one or the other party. Of course, there are a lot of issues that comes with it and that needs to be elaborated, but I want to give two very brief introductions and definitions as to what dispute boards could do. As you know, apart from the preventive function, which is the informal assistance to the parties to give some informal advice and be it at the site meeting, be it in a very short, not kind of informal way, dispute boards are issuing either recommendations or decisions. And let us not forget, recommendation is a non-binding contractual document versus a decision, which is a binding contractual document, the failure to comply with which is basically a breach of contract by whoever is committing that non-compliance. You can have both features in your board. You can have a board only having jurisdiction to give recommendations. And I think, and I wonder, both from employer and contractors' perspectives, whether these two can be used for different purposes. And I would really like to hear my distinguished colleagues' opinions on that, and help the process in any event, both of the concepts. And lastly, you will note that even in my definition, I have given the definition of a standing dispute board, which is always empowered at the beginning of the project and stays empowered throughout the project, serving the parties with a real dispute prevention method and ability until the completion. Whilst the ad hoc dispute boards are, of course, not our best practice recommendation as the DRBF, because they only have jurisdiction whenever a dispute arises, and this is not the best case scenario to have a board in place in any event. So this is a very basic information at introductory level. But even with this basic information, we are very confident, as you know, in terms of data in our database already available, that it is a fact that if this process is conducted efficiently, the projects are completed without disputes, or in the smaller circumstance where there are some disputes, you don't go to arbitration, which is a real benefit for all the parties. However, for that effectiveness to take place, of course, there should be awareness from all the parties involved as to how to contribute to that effectiveness. Therefore, today, we are going to have insights from the users of the process, such as the employer, contractor, and the engineer accordingly. To that end, perhaps we should continue with the introduction of our very distinguished panel. I'm really, really happy to be with them today. And I will start with Suzanne with the introduction. Suzanne Rattray is a senior engineer with more than 35 years of professional experience. She has a master's degree in civil engineering from McGill University in Canada, specializing in structural engineering. She has had lead responsibilities on numerous infrastructure projects in the transportation, building, and energy sectors in Zambia, Tanzania, Mozambique, Congo, and Israel. And also, as all the other panelists have, she has, of course, different hats, not only the engineer. She has been practicing as an adjudicator and arbitrator, and is admitted as a fellow of the Chartered Institute of Arbitrators as of 2017. Fanny, we could continue with Benoit.
Sure, I will continue with Benoit Dupuis. So Benoit has been advising leading companies in the energy, water, and infrastructure industries, with a particular focus on the delivery of major infrastructure projects worldwide. He is currently holding the position of Executive Director in charge of procurement, legal, and contract management at Société du Grand Paris, now Société des Grands Projets, Grand Paris Express. His practice covers a wide range of areas, including project finance, construction law, public procurement, M&A, and litigation. He acquired over the years a deep insider's view of the requirements and expectations of large companies, among the most demanding in their respective fields of activity, as regards legal support and strategic advice, and is experienced in handling complex transactions in multicultural environments.
And thank you, Fanny. And with Paul Taggart, I should continue to the introduction. Paul Taggart is a chartered quantity surveyor and a fellow of the Chartered Institute of Arbitrators. He is a visiting lecturer in the contract and claim management at Politecnico di Milano. He is a past president of the executive committee of the DRBF. He has been the director of the contract department for a very large infrastructure contractor operating worldwide. And we will be hearing accordingly his experience. Paul now acts as adjudicator, arbitrator, and is member of the FIDIC's president list since 2009. So we will probably, with these introductions, we will turn to our panel now. Fanny, shall we start with the employer's insights?
Yes, sure, Yasemin. So starting with the employer side, I would be happy to ask Benoit, Société des Grands Projets experience in terms of dispute boards, and why Société des Grands Projets decided to introduce DB's mechanism in its major contracts since 2018.
Thank you very much, Fanny, for the introduction, and hello everyone once again. And I'm very glad to share this moment with such a large audience from everywhere. It's really impressive. So Thank you for the organizers, by the way. So the question being why companies such as Société des Grands Projets decided to introduce dispute boards in its contracts, or at least in its major contracts. So for those who do not know us, Société des Grands Projets is a public company, 100% owned by the state, which is in charge of financing, designing, and constructing the new metro lines around Paris, which is called Grand Paris Express. That is 200 kilometers of new lines of automatic metro with 68 new stations. It is currently, I think, the largest infrastructure project in Europe and one of the largest in the world. So we are a major buyer, and we have a lot of contracts to deal with. The decision to introduce dispute boards in our contract results from a long discussions internally and externally. Internally, because it was debated, the pros and cons of having dispute boards before it was decided at board level, and also externally because we had also discussions with our suppliers and contractors through market sounding and discussions in order to test the appetite for such mechanism. And we decided to go for DBs in 2018-2019 with our major contract, which are essentially civil works contracts, but also some large contracts for equipment and fittings of the stations, and some of the major contract for procuring the systems. It must be understood and borne in mind that it is not a habit for French public contracts to have DB mechanisms provided for. And I think we are one of the few public bodies in France that use this kind of mechanism. And another element to have in mind also is it is prohibited for most public bodies to use arbitration as a dispute resolution mechanism in its contract. It can exist, but it is the exception. I would say the main reason why Société des Grands Projets decided to introduce dispute boards in its contract is to enhance trust among the industry. As I said, we are a very large buyer in the market. To give you just one figure, we procured more than 1,800 contracts over the lifetime of the company, which is quite short because it's a single-purpose company for one project. And that was the main reason to create trust and appetite in the market for our contract within our procurement activity. What it brings to us is maybe another issue. I don't know, Fanny, if you want me to address this issue right now or afterwards.
Yes, sure. You can go ahead and telling us what is the added value, what it brings to you, please. Okay. Would be interesting. Yeah.
Then I go on.
Thanks.
Well, it brings to us a lot, and I would say, in short, value for money. I want to say value for money because it's an investment to go for dispute boards, and we need to acknowledge it's an investment in terms of time and money-wise. But it brings us value for money all along the way. During the tender stage, because it helps us receiving more competition at tender stage. I used to be acting on contractor side before for a large number of years, but I'm not speaking with that hat today. But I know that it is a prerequisite for certain players on the market to submit a tender, whether there is dispute board mechanism in the contract or not. And I must recognize and acknowledge on employer side that this is true. We have more competition on contracts containing DB mechanism. And more than that, we also receive more competitive tenders. I'll give you just an example to share with you. We had a discussion with a contractor during negotiation stage, and that contractor told us that if we were willing to introduce DB mechanism in our contract, he was willing to reduce its offer by 1 million euro. Well, won't give you much information because I won't give you any more information of the value of a contract. But so it means that there is real value for the contractor and for us because we have a reduction in the price of a tender. And that's at tender stage. And during execution stage, it gives us more fluidity in the relationship between the parties through formal and informal discussions all along the way. There is another element which is difficult to translate into euros or dollars, but it has real value for us. It gives security to a public employer because decisions or recommendations from dispute boards, to the extent that they are properly documented and well argumented, which should be the case and is often the case, they are a very useful tool for a public employer like us to justify contract adjustments. I have experienced in previous life that public bodies could fear to agree extension of times, cost adjustment without the support of a well-documented decision from a third party. And a recommendation from a dispute board is something on which the public employer can take a decision for an adjustment in the contract. So what are the main added values? But I would define at least from a starting point from my angle as employer.
Thank you, Benoit. Also, one question that we have for you. Does it imply a regular need for external expertise to assist the DB and the parties?
I wouldn't say regularly, but yes, that's part of the lessons that we learned from our experience of dispute boards. What is essential is you have, from any side, you have to be very picky on the persons of those who will be sitting on the dispute board. And when our dispute boards are not functioning the way we expected them to, is for two reasons. Either we didn't pick the right persons or one of the parties is misusing the mechanism. But even if you have the right parties, and even they are properly skilled and have large experience, we don't have experience in anything that can happen in the lifetime of a contract. So it happens that we need external expertise with the agreement of the dispute board members, of course, in certain very specific matters. I can give you two examples. First one is geological experts that are sometimes needed by our dispute board members. And sometimes also there is a need for external advice on delay analysis. Are the two main topics on which I've seen the need for expertise, which was requested firstly by the dispute board members themselves and by the parties, of course.
Okay, thank you for these examples. And also, I would like to ask you why Société des Grands Projets contracts dispute boards decisions are not binding on the parties.
Yeah, but that might be a particularity of our mechanism, which is very much inspired of dispute board mechanism, which we have in international contracts. There was a long debate on whether the recommendations or decisions of our dispute board should be complied with by the parties, even if they were challenged. And for many reasons, one of them was a legal reason, because there is no consensus among the French lawyers on that particular issue. As I said, there is some prohibition on arbitration for public entities in public contracts, at least most of them, and having a binding decision could be interpreted as some sort of arbitration, which is not my point of view. But to be on the safe side, we decided that our recommendation should not be binding on the parties. That is sometimes frustrating from our contractors' point of view, because they would prefer, and it was the case when I was sitting on the other side of the table, they usually prefer that the decision of a dispute board is binding and complied with. However, I must say that even if they're not binding, they are very useful, because when you have a right panel and you have taken time to exchange with the other party and with the experts on your DB panel, and you have a recommendation which is consensual, because it doesn't matter for me if there are 2 or 3 members in the panel, as long as everyone is in agreement with the recommendation. Otherwise, it doesn't make sense for me. But when you have a joint decision of an authoritative and experienced panel on that issue, there is a strong incentive for us to reach an agreement with the contractor on the basis of a recommendation. Maybe the agreement that we'll reach will be a bit different, but it facilitates very much the discussions afterwards.
Thank you, Benoit, for sharing your experience, and we understand you have quite a positive one to enhance trust. And
yes, we are a warm promoter.
Yeah, that's why we invite you. No, just kidding. So I think we will have other questions for you from the audience in the end. But would you like to make a last comment before we turn to the next panelist?
No, just maybe to confirm that our experience of dispute boards is globally very positive from the employer's angle. This is why we are promoting this mechanism even to some of our fellows of other public bodies, and we've learned from some lessons from certain of our DBs. We have also changed some of the drafting of our DB mechanism. But globally, yes, we think it works. We think it brings value to all parties. And we shall be continuing to use them with our contracts to come.
Thank you. Thank you for sharing with others your positive experience. And now perhaps it may be time to turn to the counterparty, so to the contractor. So Yasemin, if you would like to take over.
I have listened with great enthusiasm Benoit's speech. You may have understood, because I have taken my notes, especially in order to understand the employer's internal dynamics as to how it views the benefits even at tender stage. And the example of that, for example, if there's a dispute board in place, we can make some commercial discounts from the contractor is very important, because, and I will turn now, of course, to the contractor to comment on that, because as we also note now in the question and answer part, what we as DRBF always receive as a question in webinars, seminars, or conferences of similar kind is that there is always concern in the party's mind about the cost of this process, of course. But Benoit's example was very good in order to compare perhaps apples with apples. So, of course, there is a cost of the service rendered by the board. However, there is definitely a real value, and even could be monetized by way of commercial discount contributed by the dispute board as well. So without my other comments, I would like to turn to Paul. Paul, perhaps we should start with the same stage that Benoit also commented. How is the dispute board process is viewed at tender stage in an international contractor's internal organization? Is it an added value or is it an extra cost?
Okay, Yasmin, thank you very much for the invitation to speak and address the audience today. That's a very what Benoit had to say. Contained some very interesting points. Okay, I mean, typically, speaking from a contractor's perspective at tender stage, okay, you look at the question of consideration. It is. Is the availability of fair treatment and ultimately justice in the event of a dispute, right? And so when you're tendering, you tend to look at, the entire contract, and you tend to look at, the dispute resolution provision within that particular contract. So, what you would be focusing on is, probably the law applicable to the contract and the dispute resolution provisions, right? Okay. Things like, is it a tier system of dispute resolution in there, right? Some form of ADR, like a dispute board or expert determination or mediation for that matter. Eventually, what is the final forum if the ADR system, is neither efficient, effective, or gives results. So you would tend to look at the sort of the wider framework of the dispute resolution provision in itself. And then I think what you would tend to look at is the matter of the independence of and functionality of those those mechanisms. Okay, you can do you have a local litigation, or do you have an arbitration? Is the arbitration, subject to local rules, or is it subject to international rules? And likewise, for the dispute board now, most contracts come with a set of rules in any case. With regards to dispute boards, the ICC, it does its own set of rules as well. But what you might be looking at in relation to dispute boards is, the appointing authority. If it's a local authority, appointing authority, or an international, appointing authority. Now, in that context, I think what contractors are generally looking for is sort of neutrality and efficiency of the system, right? That's in the contract. Local courts, local arbitration institutions are sort of sometimes perceived as protectionist and biased, even in the best of jurisdictions, it has to be said. And then occasionally you find that they are, underqualified, if you like. Also, I think some of us have had sort of, quite difficult experiences of some of the local, the local arbitration institutions, that we've come across in the international market. Now, so that's the sort of, the main framework. We frequently see, provisions for dispute boards in tenders in the multi-tier system, and generally, they are appreciated and welcomed by the international contractors. If talking, about Benoit and his client, and generally clients altogether who accept, dispute boards into their contracts. They tend to show pragmatism and an attempt at fairness, balance and fairness, in the conditions of contract. So they're generally very well welcomed from that perspective. I think, I have a sort of slightly different perception as to whether, they can, reduce the cost of a tender. I think what you tend to look at, you look at the, all the terms and conditions as a whole. You look at, liabilities, indemnities, caps, that kind of thing, and you look at the sort of harshness of the terms, whether they are onerous or not. And then, you will look at, and then you'll consider also, the client himself, the nature of the client. Is it that, does the client have a reputation for fairness? And generally, you will look at it and you will say, whether the dispute board is going to be, of some, well, let me say whether you can accept, the more onerous conditions of contract, because of the existence of a dispute board, rather than, let's say not tender at all, as Benoit was suggesting some international contractors do. You know, so I haven't seen a situation where, you know, tenders have been, you know, reduced, you know, not significantly, right? Okay, you know, that may come up in negotiation, as Benoit has said, but, you know, the existence of a dispute board in a contract is not, in my experience, led to, you know, a lower tender. Although you could argue that it could add to, you know, the risk matrix, right? Okay, and reduce reduce the percentage that's inserted for risk in it, but not of the dispute board existence in itself. I'd say the other thing, are they a cost? Well, yes, they're a cost. Okay, let me say that you know they're a cost to the tender. Okay, and you know they're a cost to a cost in the eyes of the tendering department. Okay, I mean they tend not to understand what dispute boards are about, and so what they do is you know they simply ask you, you know, give us an estimated fee, an estimated cost, you know, for this and put it in. But I mean there's a number of things you know to be considered there. I think first of all, you know, there's the cost of the members themselves, because you know there are senior members, there are less senior members, experienced and so on, and even in some jurisdictions, you know, where you may be inclined to pick a local, you know, member, then you know the cost may be lower or the cost may be higher as well. But you know, looking at it from a tenderer's perspective, you know, that's a cold cost. Okay, I mean the outcome, right? Okay, of any dispute may depend on the quality of the dispute board members, and therefore, you know, I advocate for realistic pricing of dispute boards, you know, by contractors. But the second point I would make is that by and large, you know, the cost of a board is a very, very small percentage of a tender sum, right? You know, it's fractions of a percent. Right. Okay. So you know, so contractors shouldn't be afraid of dispute boards and shouldn't be afraid of the, you know, the cost of dispute boards. Individually, the members may be expensive, but within the context of the overall cost of the tender, you know, it's fractional, if you like, you know, and you know, it's probably less than the cost of insurance, for example. Right. Okay. So I really advocate, you know, for reality pricing, and also, you know, for the, you know, the adoption of the dispute board once the job gets going. So added value, yes. Added cost, but definitely not a significant cost, and not something, in my experience, that makes a difference to whether you win or you don't win, because you know you do or don't include the cost of the dispute board.
Thank you very much, and it is really interesting to note that indeed even and from the employer and from the contractor side, there is, I mean, if this process is well known, there is the notion of a sense of security when the dispute board is in place. So that security notion is the added value in any event. So this is something that we always emphasize, but it's good to have the feedback from the practice as well. Maybe accordingly, and maybe a little bit procedural, but it could be important for the audience, I would like to raise the issue of internal organization in a contractor side for the dispute board processes. Is it an in-house effort or is it an externally outsourced effort, Paul?
Okay, my experience and my advice is it should be an in-house responsibility. You know, and that involves both, you know, at the head office level and at the site level as well. Head office shouldn't think that once the project, you know, starts, it can step away. And, you know, dispute resolution is usually something that involves some very large sums of money, you know, so, and, you know, can determine the outcome of the project. Therefore, you know, the head office, you know, should be involved. I mean, head office, you know, typically, in my experience, determines who the dispute board members, or recommends who the dispute board members should be in the first instance. But you know, and the site, you know, sort of, you know, itself, you know, performs a very large part of the the task. I mean, the tasks of the dispute board are sort of, essentially, twofold. You've got the dispute avoidance part of it, right? Okay, which involves conversations and opinions with the board, and then you have the formal side of it, which is the request for decisions, or in the case of Benoit's projects, recommendations. And normally they're performed, by the dispute board during the periodic visit. So, site organisation, what does it do? It furnishes the periodic reports to the dispute board, and organises and manages the site visits when they come, periodically every 3 to 4 months. They keep the DB informed of the progress and developments, right? Okay, including, impediments to, construction, payment, anything of that nature, time, and they appraise the DB of commercial matters, including payments and time disagreements. And the head office, they should facilitate the process from my perspective. Provide advice and guidance to the site management on the specific issues that may be disputed, and ultimately the license for for discussing and settling these things. But they should also attend the site visits as well, because there is a good level, high level of responsibility attached to it, and the dispute board, whilst it wants to talk to the site management, also wants to talk to the head office decision makers as well, who have a who have a hand in it. So what to say is it's an in-house matter. And what to say, my advice would be is build your own capacity and tell your own story, right? You can have the DB will tell you the procedural rules, right? Okay, you can hire external lawyers, or you can hire external consultants, to train you and advise you, before the contact with the dispute board. But I say build your own capacity and tell your own story. The DB themselves want to hear from the site people, right? Okay, and not necessarily from a from a third party. So I say that it's something that should be managed and dealt with by the in-house itself. And one final thing I would say, Yasmin, is contractors should remember that the dispute board is the only place that they themselves are likely to be able to explain the case in person and in their own words. Because if it goes to arbitration, right, okay, it's entirely in the hands of the lawyers and in the experts. And indeed, you as a contractor might not even recognise your case, right? Okay, that's being presented. It may have, changed, dramatically between, when the dispute was first, came to the table and when it comes to arbitration. So, embrace the dispute board concept, deal and tell your own story and build your own capacity. That's what I say.
Thank you very much. I noted a lot of things from what you have stated, and I had some also subsequent questions, but we have a lot of questions already lined up for all the speakers, and I will just take one of them with you, Paul, because it just relates to what you have just said. It's from Nick Apun, and it says, is it not true that the value of disputed issues on mega and semi-mega projects are now reaching the level of major arbitrations, difficult to deal in-house with issues of this nature? How would you like to comment? If possible, a bit briefly.
Well, I do think, I do have some sympathy with what Dick says. Okay, I do see, I have seen certain projects where the level of dispute has become so vast that, it is possible that the dispute board is incapable of performing its tasks, right? Okay, I have also seen where, the not just the money, but also the size of submissions has gone beyond what you can say is dispute board concept, 30,000 pages, 40,000 pages. I think there's two things about, what Dick is saying. Value is one thing, okay, because, a lot of money can be attached to one simple issue, right? And from that perspective, I think a DAB can probably, perform its role, fairly successfully, right? If you have one single issue which is worth 700 or 800 million, then by all means, it's something that could go before a dispute board. Something more complex, right? Okay, which includes generally a lot of different issues, is also is more difficult for a dispute board to handle, but it's not impossible, right? My own personal experience of that is that I was involved in a dispute which was in the order of around 500 million US dollars. Some of them are much larger, of course, these days, right? Okay. And the dispute board, we worked with the dispute board in order to come to some kind of path, to be able to address each of the different aspects of the dispute, each of the matters of liability, that affected the money, the time and the money. And so, with the dispute board, we charted a path through it. So, I still don't think that it is impossible, if the parties are willing to work with the dispute board, for a dispute board to deal with mega money disputes. Okay.
Thank you. Thank you very much for the answer. It wasn't an easy question, I admit that, but it's also not an unfamiliar question, because it varies upon the complexity and or size of the project, how the dispute boards could serve the parties better. So with that, I would like to thank you for now, because at the question and answer part, we will all turn back to our panelists again. We have a lot of questions. But I would like to pass to Suzanne, if possible. Suzanne, I hope you feel better, because she was having a flu earlier today. So
yes, I have a voice.
Yes, you have definitely the voice. And I would like to raise my first question with you, if that's okay. This is something, I think that comes up quite often. But the engineer's perspective is very interesting to know. What about the engineers, designer as contract administrator? What about the potential conflicts in such cases? What is the perspective?
I think that issue is there even without a DB in a project. So this, the reality of engineer having, being on the one side, perhaps a service provider to the employer, and on the other hand, being a contract administrator and having to be neutral and deciding fairly between parties, is something that a lot of engineers have struggled with, and of course has always raised suspicions naturally in the mind of contractors that the engineer will always take the side of the employer because the employer is paying the bills or whatever it is. But really, we need to understand as engineers the function of the natural person, the engineer, in their role and their capacity to carry out that function. So they need to be able to demonstrate that independence in that administration role when they are doing the function of trying to get the parties to agree something within, the contract administration, or having to make a determination. And really, that's part of the training of those professionals who are qualified to serve in the position of the engineer, because it's not, I think it's very much, it very much has to do with their training and understanding of what that is. And when we think about now the DB process, we should be the engineer needs to also, should be very happy to have another level of support in project delivery that, I have had a first crack at it. And if this is not going to be acceptable to the parties, at least there is another level at which, my determinations can be reviewed. So we're thinking about project delivery, and we are thinking about a team to deliver a project. And so the role of the engineer is to facilitate, first of all, to ensure that that trust is built between the parties, that their role in the contract administration role is a role of a neutral. Yes, they have certain functions that they have to carry out on behalf of the employer, but at the point when there is a determination to be made, then all bets are off. Now now this is the neutral zone, and it's another game completely. So really, they have that's a certain approach. That's a certain mind switch that the professional has to do. And then I think when we look at the DB having a dispute board as a facility on a project, then it's even something which, as an engineer, you really appreciate that there is if another level of eyes and minds to add that confidence to both parties, that whatever they have managed to agree, and whatever first determination that wasn't quite sitting well, that a dispute board will be able to provide, the kind of decision that the parties themselves, whether it's recommendation or decision, that the parties that can really assist the parties to keep that project moving forward as efficiently as possible.
So in other words, could perhaps we be defining it as the best practice could be the collaboration, as opposed to the usual maybe unfortunately circumstances of a sort of competition between engineer and the dispute board members?
Absolutely. The engineer has a serious responsibility to ensure that the dispute board process is fully respected and is working efficiently. I mean, it's not, if they have that, if the engineer is insecure in some way, then, it's going to be problematic. The process is not going to work as it's meant to do. So they should have that, confidence that this process works for the parties. They should have the confidence to encourage the parties to fully engage both sides. They should not be concerned about themselves. So really it's taking the ego out of the story, which maybe is, for some it's harder than for others. And really to work to get, to be encouraging both sides to engage fully with all of the aspects. I mean, the engineer normally is in the contract administration role, is having access to all of the information, all of the records, things are, is normally a repository of many documents. And so building that relationship with the dispute board, making sure that all of the information that the dispute board wants is provided in a timely manner, everything is available, ensuring that, everyone is well prepared for the periodic site visits, is, open about any questions they have. They have an issue that they have to evaluate, they're not quite sure how to go about, is able to bring these things out rather than, trying to hide them under the table and hope nobody will notice. I mean, it's that, it's just not going to work out. We know it. So I think that if the engineers who are appointed on the projects are the ones who can really have a strong influence on building the confidence of the contractor and the employer in the dispute board process. Say, look, we have these experts who can help us to, whenever we get stuck, we have this facility that can help us. So let's get stuck in. Let's use them to the best of our ability.
And so how about the engineer as employer witness in a hearing? What's the impact going forward then?
I think
okay.
one of the things which can happen in hearings is it depends on how the dispute board members are the ones who will manage the hearing process. So it is not like arbitration hearings where all kinds of things can happen, and all kinds of things can be said and questions asked and all the rest of it. So the dispute board members really manage that process well, and they will ask the questions for the to the engineer, what actually happened at this point in time in this particular situation, and they will, it will not be trying to accuse people of not doing the right thing. It'll be just about gathering the facts and the nature of them managing that process. I think no one at the end of the hearing process leaves the hearing feeling like, my engineer let us down in that process, they didn't fight back or whatever. It's not the same kind of process as we have in the adversarial processes in arbitration hearings. It's quite a different nature of a beast. So I think the idea for the engineer to be able to certainly in their role as being a representative of the employer and being able to provide that guidance, that my role here is to give the facts as they were. This is what happened, and it's not my job here is not trying to spin a tale to the best advantage, just to answer the questions of our board and help assist the board to come up with the best, most just decision possible. So I think that, that level of education between and understanding between the employer and the engineer makes a difference. That going forward, I mean, even whoever, even if the employer is not, is not successful in, in the outcome, I think the relationship, I don't think that it impacts the relationship going forward because of the way in which the dispute board process and the hearing process is, because it's quite different from an arbitration process.
So in general, you mentioned it already a little bit, the importance of education and training for engineer on that process. Maybe that's really the key issue.
Yes,
really.
Absolutely, yes, because normally, I mean, you will have your technical training, whatever specialty you have, and you will have your contract administration training, but the training in the dispute board process. So first, the philosophical underpinnings of the dispute board process, what really we are trying to achieve. If you don't know, I mean, if you don't understand that, then you will not enter into the arena with necessarily the correct approach. So to understand what it is that, or why is it that we are having this process in the first place, I mean, then you are able to be much more effective in terms of how you're going to interact with the process. So I think it's really important for engineers who are, who will be the engineer on projects to do training, the dispute board training, so that they understand exactly what this process is about and how important their interaction with and their engagement with this process is in order to make it a success. Because, I mean, it is a very successful process. It can be, and the alternatives are not good. So I think we should really, just to put it mildly, so I think we should really try to get as many, of our colleagues as possible, educated on this process so that they can really contribute much more effectively.
Thank you very much, Suzanne, for the good recommendations and also warnings. Thank you. And maybe, Yasemin, you would like to go through the Q&A?
Yes, in the meantime, I have just scanned through the questions. We have a lot of them, and in the Q&A part and in the chat section. I thank Andrew Rousseau, our Executive Director, to be coordinating those questions, to be able to answer all. So without delaying, I would like to pass the Q&A part, and I will be raising questions with our panelists, if possible. So the first question goes to Benoit from the audience, Ignacio Almagro. How does the use of dispute board fit within the national legal framework, for instance, enforcement and recognition by public entity? Although you have answered part of it by the recommendation nature you have in your contracts, but please take the floor, Benoit, to address.
Yes, thank you, Yasemin, and thank you for the question, because it's a very good one. It's a bit tricky in the French legal system, because as I said, the public contracts or the disputes are to be submitted before the French administrative courts. As a result, the recommendations and they're not decisions, they're recommendations from a dispute board. They're not enforceable before the court in France. And this is the reason why we use the dispute boards more as a dispute resolution mechanism to assist the parties to find the right solution on the basis of a well-funded recommendation. But you cannot enforce in front of a French court a recommendation from a dispute board.
It is not surprising for us, because maybe some of the audience would have already participated in our MENA seminars and conferences. We always discussed that the enforcement should not be necessarily through legal means. Enforcement also covers amicable settlements by, after issuing of a decision and or recommendation. So it makes perfect sense that whatever fits the best to that public authority in order to use this concept could contribute to the efficient conduct of the whole process. Thank you very much. And okay, I'll just go through some other questions. Another question perhaps needs to be raised with Suzanne. Is the engineer needs to proactively keep the DAB updated on behalf of employer regarding the potential issues which may arise due to actions or no actions on the part of contractors?
I think the engineer needs to keep the parties engaged in the DB process. So the engineer needs to keep, make sure that the DAB gets the required information. So if not only information related to what contractors are or are not doing, it's also equally what the employers are or are not doing. So really, it's the information of the contract itself, how the contract, so both parties need to be involved together with the engineer in this engagement with the DB. I think that's how we're going to build the confidence that it's the dispute board is there to be neutral and to facilitate any first prize avoidance of any dispute. So to get them the information so that early on they can start to consult with the parties about things which might be brewing and how things might be prevent it from escalating. So it's really information related to both sides. I mean, normally, the major issue from in terms of the obligation from the employer side is basically paid, just pay the certificates kind of a thing. But I mean, there could be many other issues as well, including timely decision making. So there are all of the issues which are there on the contract as they're bubbling up. I mean, the information needs to be shared with the dispute board, and the engineer can facilitate that sharing of information. So I wouldn't restrict it to what the contractor is or isn't doing. I think it's the parties. What's happening with the parties? What are the things which may be issues, which may be becoming disagreements, which may be, as things, so that the DB can intervene early and, assist the parties to nip things in the bud and not necessarily blow up into major disputes.
Thank you very much, Suzanne. I move with another question, and this time I would like to raise it with Paul. Some of the questions are addressed directly to some of the panelists. So Paul suggested choosing an internal board. I'd like to inquire about the selection process for internal board members. Are they chosen from each side, persons from contractor and employer? Also, do they receive payment throughout the project? Paul, perhaps you would like to clarify the issue, perhaps the in-house organization explanations,
Yeah, there's maybe a misunderstanding there. I think the question was, how do you organize? And, my answer was, sorry if it was not clear, was that basically, in terms of, acting as a contractor, my view is that, you should build, it is an in-house task, for the contractor, to deal and manage with the dispute board. Okay. What I recommend is sort of, building capacity in-house to be able to do that. Now, if you don't have the capacity or experience, then you can always go to an external source to get some training, okay, in order to put you in a position to be able to interact with your board properly and utilize and exploit your board properly as well, because board is an expensive item, although it's not in the terms of within an overall tender, but individually the members are can be considered expensive. So I wasn't suggesting an internal board. What I was suggesting was an internal in-house management of dispute boards, okay, and get the training and get the experience and build the capacity. Okay.
Thank you very much. So in any event, let us not forget that board members, and perhaps this will be the subject of another webinar, need to be independent and impartial from the parties. So there is definitely that conflict issue, and none of the parties, including the engineers, could take parts of any dispute board for the same project for conflict-related matters. I proceed. I mean, I don't want to exceed our time. However, I want to take as much questions as possible. We had over 20, so I'm trying to choose. And this one is from Alfonso Pelosi and addressed to Benoit. Mm-hmm. Are the members of the DAB appointed on mutual agreement, or each party appoints its member, as in Italy? Was it simple and straightforward to appoint the members, or there were disagreements in your experience?
Our experience is that all the members are jointly agreed by the parties. Of course, each party is proposing one member, and it has to be approved by the other party. And then the two members are proposing a third member who is acting as a president without any casting vote, but being the president of a board. Essentially, I would say that even if each party is proposing one member each, at the end of the day, the 3 members of the board have to be agreed by both parties, and they have to be comfortable with all the members. Otherwise, it doesn't work.
Thank you very much. It's kind of very much aligns with the legal requirements as opposed to the real purpose of this whole mechanism. In the parties to understand the value and to add to that value. So the agreement is really core, the agreement and the trust between the parties. Okay. Another question, I think it goes to all our panelists who would like to reply, by Volker Jurovic. Has it ever been considered to ask tenderers for 2 tenders, one without DB and alternatively one with a DB? That might demonstrate what the contractors think of the value of a DB.
As far as I'm concerned, I've never seen it, either on contractor side or on employer side.
It's a very interesting and it's a very interesting question. But like Benoit, I have not seen that before, right? But I'm not suggesting that it couldn't be considered.
Normally, at least the contracts in this part of the world, the DB provision is a provisional sum. So the employer would have made some kind of an estimate of, it could be completely off, but let's say that they have some realistic estimate of how, they know, okay, there'll be periodic site visits every 3 to 4 months. They have some good idea of rates, and they might have a guess that maybe we'll need X number of decisions over the course of this, and they'll have a figure. They'll do some maths and they'll come up with something. So, there will be a figure there. So as a provisional sum. So, that, I don't think the with or without doesn't come in this case, because that the figure for the DB is something which is already defined. So the only thing that happens theoretically, maybe Paul can say if he knows from the contractor's point of view that now the contractor looking at, okay, so I have to come up with the equivalent of that amount of money, my 50%, and spread it across my rates somewhere to be able to cover the cost of what it is. I think that's the only thing that I can imagine would be happening in the minds of contractors who understand this process. Because if the employer this is a provisional sum for DB to cover their share of the DB, which is what happens in the MDB funded contract. So there's a provisional sum in there to cover the employer's share of the DB. So that means the contractor has to find an equivalent amount of money and put it in his rate somewhere to cover up for his 50% share of what it may be. That's so it's only if there's no DB, then that money wouldn't be there. But then, of course, you have the cost of the alternative.
Perhaps that's the thing, that how to commercially monetize the value of the board as opposed to the cost, which is much easier, of course. Yeah. Benoit, you were saying something. I'm sorry to interrupt.
Oh, no, I wasn't saying anything. I was totally in line with what Suzanne said. I don't know how you can monetize. What I know is that in certain, it can happen that you provide for a dispute board at tender stage, and then you award a contract with a dispute board, and it's somewhere in the price because it has been built into the price. And then for the contractor, for some reason, doesn't want to have a dispute board in place. And one thing I learned is that you don't force it. So if one of the parties don't want the dispute board to be in place, well, we don't force a contractor to have a dispute board if they don't want to have it. And maybe there is a saving, at least on a short run from the contractor's angle, not having the dispute board in place?
Thank you very much. Very good statements that I have taken notes. And I'll just take another question, and then we will complete this very, very useful session. And maybe one reminder that, you know, we are recording this webinar, and both institutions will make sure that the recording will be shared with the participants. So the last question is for all the panelists. What are the assurances for impartiality of adjudicators? Do you believe, although non-binding, the DRB's decision will impact the decision of the arbitrator? So there are actually two questions there, two unrelated questions.
Could you repeat the second question?
Okay, so the first question is about the assurances of impartiality for the dispute board member, how the system, you know, is established. And the second question is, do you believe, although non-binding, the dispute board's recommendation will impact the decision of the arbitrators? So at the subsequent stage.
Okay.
Well, I think in terms of assurance of impartiality, who can assure anything about any individual person? I think the idea is that there's a code of conduct for adjudicators, and so anyone who is not impartial or independent, there are consequences, and there's a very short career. So I think the system, I think the professionals themselves will take responsibility for any lack of impartiality or independence, because there will be consequences that flow from the contract, because they have to warranty certain things. So I think as professional adjudicators, that's really professional suicide. Now, on the decisions or recommendations of the dispute board in a further stage, I think as an arbitrator or as an adjudicator preparing a recommendation or a decision, you are, of course, writing the best decision or recommendation that you can based on the information that has been provided to you at the particular time for the parties, knowing fully well potential future audiences, including possibly in arbitration. And I think what I have seen, my experience of adjudicators, is that they take this very seriously. And they will normally have it in their mind that they will want to be as precise as they can be within the constraints of the time and all the rest of the information that they have. So that will be the value of it. But of course, the arbitrators are not bound by whatever it is that comes from the previous decisions. But generally, we can see certainly in those tiered systems where decisions go forward to arbitration, that there's a very high percentage in which the arbitrators come to the same decision that the adjudicators come to, just because of the level of professionalism that's involved in the adjudication process. So that's what I would have to say on those points.
Any additions from the panel?
Maybe I must say that I agree 300% with what Suzanne said, and essentially the fact that the reputation is maybe the only asset of the individuals that sit on the DB, and that is true either for us on this table and probably for most of the audience as well. But if you choose carefully the members of the panels, then you should trust them. But of course, we check the information, we check the level of relationship between that person that is proposed by the other party and that party. But yes, I think the reputation element is the best answer to the first question. And I must say that I'm unable to answer the second question, because I was used to have DBs with binding decisions, so that had a direct effect on arbitration, because you could enforce the DB decision directly. And in our case, we have a simple recommendation, not binding on the parties, but we don't have recourse to arbitration because we cannot. And it has no effect, of course, on court decision. But I would tend to think that in the case there were a non-binding DB decision followed by an arbitration, I would tend to think that the non-binding DB decision would have an impact on the decision of arbitration. But that's just a feeling.
Thank you, Benoit. Anything from your end, Paul?
Well, just in reverse order, with regards to the, whether the arbitrator is going to be influenced by the dispute board decision. I think just to remind ourselves that, when it goes to arbitration, the case is heard de novo. So, it's, rerun entirely again, and with a lot of different, and possibly with a lot of different and more evidence as well. Not possibly, but more than likely. So there is that aspect of it, and I think, like Susan, I think the professionalism and reputation of the arbitrators is on the line at that particular point in time, right? Okay, so whilst they might read the DB decision, I think they're certainly not going to rely on it in any, they will go with the evidence that's presented for the case. What I would say is that, it's a brave move, going to arbitration after the dispute board decision, particularly when you have a very high and professional level dispute board, because it's possibly going to cost you more money to get the same result. In fact, it's not possibly, it's definitely going to cost you more money to get the same result, 10, 15 times more money than you would spend at the dispute board level. Okay. With regards to, I think the other item with regards to impartiality and independence, I think my two colleagues, Susan and Benoit, have covered that more than adequately, and I would just be wasting your time. I couldn't do better than they have.
Not at all.
Than them. Okay.
Well, thank you very much, Paul, and thank you very much, Benoit, Suzanne, for your very valuable insights and comments today. There are many other questions that we could not address due to the restrictions of time. However, I would like to take the opportunity to invite all our participants to our other webinars in CICA and in DRBF, respectively. And as CICA DRBF cooperation, we will be organizing this as a series, so there will be more of these. Please come join us. And as Fanny stated, the next one will be in October. And in between times, I would like to thank our audience as well. They were very interactive. We enjoyed it a lot, this very useful discussion. Thank you very much and hope to see you again. Fanny, if you would like to add.
Thank you very much to all. Yes, as Yasemin has just said, we will be very happy to see you all again for the next webinar in October, and hopefully maybe also in Paris for this in-person conference where we will also discuss dispute boards. So thank you very much and see you soon.
Thank you. Bye-bye.
Bye-bye, everyone.
Bye.
Bye.